What is hearsay? Hi, my name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by talking a little bit about what hearsay is and how that might apply to your case. So, hearsay is basically an out of court statement made by a declarant outside of court, a declarant meaning a person, like you, me, whoever, that's being offered for its truth. So, as an example, let's say you're in court and the attorney, whichever attorney is examining you, says, "Well, how do you know they slapped their mother on a Thursday?" And you say, "Well, their mother told me that Thursday night after it happened." Well, that's a hearsay statement. It was a statement made outside of court because it was made that Thursday night by the person who was struck, and that it's being offered for its truth. That's an inadmissible statement under the rules of evidence here in Oklahoma. You can't just say, "Oh, well, so and so told me one day, and so that's why I know this." That's not enough. You need to be able to have that person actually there, physically present in court to testify to whatever they said, to be able to actually prove its veracity. Here's the reason for it: is because under any just about any state's rules of uh, civil procedure and criminal procedure, you're supposed to have the right to cross-examine the witnesses that are testifying against you. So if someone's just saying, "Oh yeah, well they told me last Thursday that this happened," and they're not there to be cross-examined, then how are we able to really determine the veracity of that statement? This also comes into play. Sometimes I'll see people, they'll try to introduce text messages with another person or some sort of written statement from another person. That's not good enough under the Oklahoma rules of evidence, because you have to be able to either verify what they said in some way, or you have to be able to cross-examine them. Now, there are some examples to hearsay, and I'll get into those at a later date in a different video. But for right now, the biggest thing I have to tell you is be very, very careful of what you are saying when you are on the stand. So many times I will either be objecting or the opposing counsel will be objecting, because my client will be, or the client will be giving testimony, and they say, "Well, I know this because so and so told me." And right there at that point, as soon as you start talking about what somebody else said to you, it's hearsay. And outside of a certain objection, it's going to be, or certain exception, it's going to be inadmissible. If you have questions about this, or if this is something that you think that maybe you should still be allowed to use whatever evidence you have, give me a call. We'll start going over the exceptions to the hearsay rule. Let's see if there's a way that we can still get it in. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy. Thank you.